A major ruling in the Seminole Heights murder trials. Prosecutors will not be allowed to present evidence of all four killings in each of the four separate murder trials per a judge's decision released moments ago. A legal breakdown of the pivotal ruling begins now on WFLA Now. Hey there, folks. JB Buno. Welcome to everybody joining us here on WFLA.com, the WFLA app, and of course on our various social media pages. Howell Donaldson III is accused of terrorizing the Seminole Heights community in 2017. 51 days of terror, shooting and killing four people during that time before getting caught, again, accused of those four horrific murders in 2017. It's been quite the legal saga ever since. A trial is yet to actually get underway in our legal system. There's going to be four of them per a judge's ruling, and now this decision just coming down a moment ago here in Hillsborough County, Florida. As we understand it, prosecutors will not be allowed to present evidence of all four killings in each of the four separate murder trials. To help us kind of break this down, bringing in Bryant Camareno, a very well-known criminal trial lawyer here in the Tampa Bay area. Bryant, thanks so much for taking time out of your day. We are reading the same ruling that, of course, you've just received in your inbox. What does this mean to you from a legal perspective? You've, of course, dealt with many criminal cases here in the Tampa Bay area. What does this mean to you here legally?
Legally, it's a huge win for the defense. The Williams Rule evidence, that's the name of the case law that allows prosecutors to try to combine unrelated cases into one criminal trial for a jury's consideration. So Williams Rule is a powerful tool, and they are routinely granted. Judges routinely allow the prosecutors to allow all this other evidence of other crimes to show motive, identity, preparation, absence of mistake, and so on and so forth. But in this case, Judge Ward issued a pretty lengthy statement, a 5-page statement or order outlining why it should not be allowed. So it was a huge win. And so that means now the defendant's going to have four separate trials, as it should be. And each respective jury is not going to be allowed to hear about the other alleged murders.
Yeah, this is it seems to be a pretty pivotal decision here in this case. Judge Samantha Ward, if you might remember, folks, granted the motion to sever these the killings themselves, the four killings themselves, into four separate murder trials. Brian, can you give us a little bit of precedence there? Is there precedence for that sort of a decision? Do you agree with them being broken down into four separate trials rather than being in one from a legal perspective in all of your experience covering criminal law here in the area?
Sure. As a matter of fact, you had these four different murders, and so they were all charged individually. They were charged as one single episode, one criminal episode. So ideally, prosecution wanted the jurors to hear about each other murder that occurred. So routinely, defense attorneys asked to sever, and routinely they are granted. So in this case, initially, Judge Ward did the right thing by severing them. By severing them, now it minimized the strength of the prosecution's case as a whole. So they came back under this rule, under 404, and asked the judge, all right, well, since now you've severed these cases, now we want to introduce aspects of each murder into one trial, into the other trials. So even though they're four separate, we want the jury to hear about murder number 2, number 3, and number 4 under Rule 404. So as a result, yes, they're routinely granted motion to sever, but at the same time, remember the state routinely then uses the Williams Rule evidence to consolidate the offenses, so to speak, and those are usually routinely granted as well. So when I read the ruling, I was somewhat surprised. I think it's a very smart move by the defense to ask to object to the Williams Rule, and it was a very wise decision do this because, again, the danger of unfair prejudice is so important that this defendant get a fair trial. So it's a great ruling. And there's another rule under 403 where the judge has to do a balancing test. And even though she didn't cite Rule 403 in her order, I'm sure that had to weigh heavily. It's the balancing test of whether or not the state gets to produce these crimes, these collateral crimes, and the fairness to the defendant. He's entitled to a fair trial. So the state is entitled to a fair trial. So is the defendant. So if you introduce all these collateral crimes, it has the undue effect of being unduly prejudicial. It could taint the jury. And that's, I think, what the judge was trying to prevent from happening.
So one of the lines here, Bryant, that really caught my attention here, it's on page 2, and it says, such evidence is inadmissible when the evidence is relevant solely to prove bad character or propensity here. It clearly, what Judge Samantha Ward here is clearly demonstrating, based on, again, on my reading of the ruling here, is trying to preserve the, if this is correct, preserve the integrity of the evidence for each individual murder trial, rather than connect them to craft a narrative across four, trying to treat each individual one as separate. Does that sound right to you? Is that kind of on the right track here?
Absolutely. So let me, exactly. So in layman's terms, so the way it works is the judge was worried. So let's look at it from this perspective. Judge wants the defendant to have a fair trial. She had ruled opposite or against the state, the defense, and allow the Williams rule. The appellate court could have easily said, Judge Ward, you did the wrong thing. And now you're running the risk of having those convictions overturned, then have to try it all over again and bringing more grief to the parties, the victims, the families, and the defendant, an unnecessary tax burden on the state. So by couching her order in that way she did, it justifies her ruling. So remember, the state can appeal. Now, I'm not sure if they're going to yet. It's too early. They have time to appeal. They can ask for an interlocutory appeal and ask the above courts, the higher courts, to say, look, Judge Ward was incorrect. But absolutely right. So when they talk about bad character, what Judge Ward is trying to prevent is to taint this jury that he is such a bad guy. He's only accused of this one murder. These other murders that he allegedly committed, that's going to have that undue effect of, again, giving him this bad character, the propensity for being a bad guy. And you have to look at each defendant solely and presume him innocent, not be tainted by these collateral. It's a correct ruling. Again, so to answer your questions about the bad character and all that, I think she had to do it that way so that when the appellate court reviews it now, I would imagine the state's going to appeal, they can see now why Judge Ward made that specific ruling.
When you're looking here at I'm looking here at some of the comments that we have, Brian, coming into our social media comment section. There are some folks here that are frustrated that this has been years of this now, the legal process to get us from A to B, so to speak, and actually getting one of these four trials underway. It's been, of course, a years-long process here. What can you say in relation to now the weight that people have had, people who have wanted justice for these four individuals who were killed, people who have been demanding justice for the four people, the individuals that were killed in the Seminole Heights murders, for people that are getting a little bit antsy here? Is this normal as far as the wait here for the trial to get underway?
Absolutely. I think everyone can respect what the victims are going through, the families are going through. Everyone wants a speedy and just trial. I think they also acknowledge, I'm sure the prosecutors have told them, listen, we can rush this. If we rush this, and for some reason the lawyers, the defense attorneys are not prepared, and he's convicted, he's going to come back on appeal. And so let's get it right the first time. And I think, again, that goes into what Judge Ward was thinking. Let's do it right the first time. Let's exclude all this collateral evidence. But the timing, you're right, the pandemic did not help. Everything was at a halt because of the pandemic. Literally almost a year was taken away from these defendants who have been sitting in jail waiting for trial. So when you add the normal stress of preparing for murder trials, that all came to a halt because of the pandemic. Now we're starting to pick up again. So the best message to the victims and the public at large is it has to run its course in its due time. If you rush it, and you run the risk of having it come back on appeal, and imagine having to do this again in 3 or 4 years. This way, and a perfect example is the Oscar Ray Bolin. If you remember that case, historically, that came back so many different times. I think it went on for almost more than 10 years with all the reversals and the retrials. Imagine the stress that those victims had to go through, having to rehash same trial 3 or 4 times. And I think that's what they're trying to avoid. So I think Judge Ward, perfectly, let's get it right the first time. Yes, it's going to take its time. We're opening up again. Let's do it right. Whatever the verdict may be, let's do it right so we don't have to come back and do it again.
Let's change roles here a little bit for you here, Brian. If you're State Attorney Andrew Warren reading this ruling, if you're the prosecutors on this team that have been working on this case, if you're on the flip side, you're trying to prove guilt here. First of all, you're trying to prove guilt here on Howell Donaldson in 4 separate murder trials rather than one concise one. And now you're being told that evidence can't really be carried over from one to the other. If you're Andrew Warren reading this, if you're a member of the prosecution team reading this, what's the first thing that goes to your mind? How big of a detriment is it to the case that they're trying to present?
So I think it's an excellent question. I think the first thing goes through my mind, if I'm Andrew Warren or any other prosecutor, is do we appeal? Do we stand a chance? If we appeal, talk about another break, another halt in the proceedings, okay? So you need to talk to the family, the victims, and say, look, we can appeal Judge Ward's ruling. We can respect it, but we can disagree. Let's appeal. Members of the family, if we do this, you're talking about another 3 to 6 month delay. So if the victims are okay with that delay, the appeal. That's number one. Number two, if they don't want to appeal, if the victims say, that's fine, analyze the case and say, hey, do we really need these 3 other murders to convict them of one? And so on and so forth for the other trials. So I think what's going through his mind right now, and the prosecution team, all great lawyers, is could we appeal? And I think why not? If I were the prosecutor, what do we have to lose? Let's appeal. Judge Ward might get reversed, and that Williams rule evidence can come in. It's easier said than done. But as long as the victims are okay with it and waiting another 3 to 6 months, if not longer, let's have at it. If not, let's go without the Williams rule. So I think that a little bit that I know as an outsider, I think there's enough evidence there that I don't believe they need all this Williams rule evidence. But I get why they want it in there to ensure that conviction. So I would appeal. Quite honestly, if you appeal to the Second District Court of Appeals in Lakeland, you're getting a little bit of taste of what they might say, what they might have said had the Williams rule allowed to come in to begin with, and possibly overturn the conviction. So let's run its course. Let's do the appeal and see what the appellate court says about Judge Ward's ruling. If they sustain her ruling, fine, let's go forward. And then it was better to find out now than to have a conviction reversed because we did let the Williams rule evidence in.
That was my question: was do they feel that the evidence is there a chance where they say the evidence here is strong enough that we feel like that we can present it in 4 individual trials, that it's just a waste of time for an appeal? Because an appeal, I would imagine, is somewhat of a long shot, or do you believe it's a long shot, the success of launching an appeal here for this ruling?
I don't necessarily think it's a long shot. There's so many cases out there on Williams rule. Judge Ward, to her credit, is not the only judge to say, oh, we're not going to let this Williams rule evidence in. So, and there have been other judges and other appellate decisions that have reversed a lower court's ruling. So I think it is worth a shot. If I'm Andrew Warren, let's run it. Let's do it. Let's run the appeal. Again, knowing that it's going to take another 3 to 6 months, let's do it. So I don't think it's a long shot, and I think it's worth a shot if I'm the prosecution. What you said a second ago in terms of the question, not knowing the facts as well as the state does, but from what I do know from reading the articles and talking to other sources, I don't know if they necessarily need it. Again, if the appellate court says, Ward, you were incorrect, great. Now we can admit the Williams rule and then almost ensure the conviction. Again, if I'm looking at it from a prosecutor's perspective, I don't think it's a long shot at all. I think it's worth a shot if I were, the prosecution.
Brian, my last question I'm going to ask you pertaining to, of course, again, for those of you just joining us here, you can read more on WFLA.com. We're going to have more in our newscast tonight here on WFLA News Channel 8 being joined here. Brian Camareno, of course, criminal trial lawyer here in the Tampa Bay area. Brian, you've covered, of course, you've been on the bench for many a trial here in the area. The question I want to ask you pertaining to this, and I'm seeing our social media comment section light up with a lot of folks, of course, who followed the Seminole Heights murders here in the Tampa Bay area. Of course, everybody, remember, if you were living here at the time, it was something that you couldn't escape. It was on the news every single day, extensive coverage across pretty much every television station, including ours, the papers. It was quite the experience. But when you're talking about what I'm seeing here in the Facebook Live comment section is, oh my God, this is going to be made into a Netflix series one day. People are talking about, of course, there's a lot of focus here in the Tampa Bay area and really across the state of Florida on the Seminole Heights murder trials. And subsequently, when they do get underway, from a prosecution standpoint or from a defense standpoint, with all of the media attention that falls on a trial, how much does that change things for either the prosecution or the defense when we're talking about just how many people are watching and how much media is present as far as covering the trial itself?
Well, listen, absolutely. I think the media will absolutely have an impact on potential jurors. For people that are going to watch this now, streaming right now, or even later on the news, that are going to be picked to serve at least on the panel, on the veneer. And so at some point, we're going to know more about the case from watching the media than actually from the facts. So that there is a danger. The First Amendment prevails. You have the right, you have the right to talk about this newsworthy event. I am a listener. I have the right to know about this. I want to know what's going on. So it's going to have an impact. I wish I could say that it wouldn't, but it's going to. Hopefully, through the streamlining process of the jury selection, be able to weed out the people who have already made up their minds. And I think you'll find some of those people. But there is always an inherent danger that people are going to, on this case, you can already know what happened just based on watching. But you can't, the First Amendment right and his amendment, the defendant's right to a fair trial, they're not inconsistent. So it's going to have an effect. But hopefully that'll weed out. As far as the emotion of some of the viewers and the listeners, listen, I've lived in Tampa for the most part all my life, and I remember this was absolutely shocking. We were all on edge. We got to put emotions aside. We want justice, whether you're on the defendant's side or the victim's side. We all want justice. But if we rush the process without knowing what some of the comments are, I know let's get this over with. I can only imagine what some people are saying. Straight to the gas chamber if that even existed anymore. We got to set that aside, because if we don't do this right the first time, we're going to be hearing about this 10 years from now when he wins an appeal because a judge made it an erroneous decision. So my suggestion is, absolutely be angry, scared, be supportive. But put that aside, because if we don't do this right, this is going to story that you're absolutely right. You're going to be talking about on Netflix or the news or who knows, how many years into the future. Let's just get it right the first time and let justice prevail whichever way it falls.
Criminal trial lawyer Brian Camareno, right here in the Tampa Bay area. Thank you so much for your time, folks. Joining us here at home, you can read more and the latest on this story and this the judge's decision on WFLA.com and the WFLA app. The very latest coming up on WFLA News Channel 8 at 6 o'clock.